Hello and welcome to this Constitution Unit seminar on improving parliamentary scrutiny of international agreements. I'm Lisa James, I'm a Senior Research Fellow at the Constitution Unit and I'll be chairing the discussion. International agreements are a crucial tool in modern governance. They form a key element in how governments approach many of the highest profile political issues. But they're traditionally the preserve of ministers and officials, with legislatures getting relatively little look in and often only quite late in the process. So why does the scrutiny of international agreements matter? And how can it be improved? To discuss these questions, I'm joined by a great panel. Our speakers are Peter Goldsmith, Lord Goldsmith, Chair of the House of Lords International Agreements Committee, which has just published a major new report on the workings of the treaty scrutiny process. I'll be putting a link to that in the chat in just a moment. Arabella Lang, who's head of public law at the Law Society, and as a former Commons official was the founder of the Parliament and Treaties Hub in the House of Commons. And Clare Adamson, MSP, the SNP MSP for Motherwell and Wishaw, and convener of the Scottish Parliament's Constitution, Europe, External Affairs and Culture Committee. So each of our panelists is going to speak for around 5 minutes. After that, the four of us will have a brief panel discussion and then we'll open up to audience questions. And if you have a question, you can submit it through the Q&A function at the bottom of the Zoom screen. Tom Fleming, who's here on screen with me, will select from among them and he'll put questions to the panel. And by default, he'll also share the questioner's name, but you can submit your questions anonymously if you would prefer. One thing you might want to consider is that this whole session, including the Q&A, is being recorded. We'll be posting the video shortly afterward, and the event will be available via the Constitution Unit podcast. So, with the housekeeping out the way, let's get into our discussion. Lord Goldsmith is going to kick us off. Over to you.
Thank you, Lisa. I'm delighted to be here. I'm actually particularly delighted about the panel as well, because Arabella Lang gave evidence to us, so it's very valuable to have her input. But Clare Adamson too, because one of the things we do talk about in our report is the involvement of devolved nations. And so I'm very keen and delighted that Clare will be giving the perspective of Scotland in that respect. So our committee, it's now 5 years old. We have the job of scrutinising all international agreements. And because it's 5 years old, this seemed to be a good time really to look at how scrutiny is operated. It's also the fact that government hasn't really heeded previous calls for reform. So we thought more needed to be done and we need to look at it again. We needed to look at it carefully and get a reaction. And the important point, I think, is that our report actually draws on our experience as the only body in Parliament dedicated to treaty scrutiny. It covers how the treaty scrutiny process under the Constitutional Reform and Governance Act has operated during our lifetime, whether the government's objections to reform are valid and recognising the legislative reform takes time, recommendations for practical and operational changes to make scrutiny under the current legislative framework more effective. So first of all, how has CREG operated? Well, I suppose the most important thing is our experience is that the 21 days, that's Parliament sitting days, but still 21-day scrutiny period, does not allow Parliament to conduct an in-depth evidence-based review of a significant treaty. Now, it's fair to say only some treaties fall into that category, and we sift out about 2/3 of the treaties laid in Parliament, and only a few of those we report on are then recommended for debate. In fact, in the last 12 months, we've had 4 debates: Chagos, Ukraine 100-year partnership, US mutual defense agreement, and a defense agreement with US and Australia, the AUKUS treaty on cooperation to enable Australia to develop nuclear-powered submarines. So all very important topics. The minority of significant treaties, though, deserve more attention in Parliament than the legislative timetable under CREG allows. The government's insistence on 21 days doesn't take account of what's involved in proper parliamentary scrutiny, in particular, taking evidence from outside, from stakeholders, from people who understand the issues, the experts. And government have refused extensions, even in cases where they accept that the public interest is high, and indeed there's no urgency. That happened in relation to the Chagos agreement. Equally, they refused to say what factors they take into account when considering extension requests. I can't see what the justification for that is. At least we know what we need to show in order to get an extension or what matters. But government has accepted that since the time of the UK's exit from the EU that more time is needed for free trade agreements. Informal arrangements have therefore been put in place, which usually give us significantly longer, 3 to 4 months, to conduct an inquiry into a free trade agreement. That's underway at the moment for the UK-India free trade agreement. The Department for Business and Trade provided us the treaty text and a draft explanatory memorandum shortly after the signature of this in July, and the trade agreement will not actually formally be laid under CRAG until early next year. So that gives us time to call for evidence and to give the treaty the in-depth scrutiny it deserves. But the thing is that free trade agreements are not the only treaties that need that sort of enhanced scrutiny. Just take, for example, multilateral environmental agreements, such as the Paris Climate Change Accord, or the new WHO Convention on Pandemic Preparedness. They're two very strong examples. So what are the government objections to reform? Well, are they valid? We concluded in short that they're not. Firstly, government frequently cites the dualist nature of the UK's constitution as a reason underpinning that. But evidence to our inquiry was that there are many dualist countries with stronger scrutiny practices, including many which impose actually a requirement for parliamentary consent. And the second reason is, and it's connected with that, is government says Parliament gets to scrutinise when it implements legislation. Well, there is sometimes implementing legislation of some part of treaties, but scrutiny of the implementing measures is, in our view, no substitute for proper treaty scrutiny, because Parliament needs to be able to look at the treaty as a whole and the policy reasons underpinning it. And that policy is locked in by the time the treaty is laid. And the implementing measures are often limited only to specific items of the treaty. Third point is that government says it needs flexibility to strike deals in the national interest, and that CRAG provides an appropriate balance between flexibility and accountability to Parliament. Well, we looked at that. The reality is that the CRAG process gives the government too much discretion to decide if it wants to have a scrutiny. It can evade scrutiny, frankly, quite easily. For example, by denying an extension of time, or simply the form of agreement that it chooses to enter into to record the agreement. So we did conclude that legislative reform was needed, and there is a powerful case for providing for parliamentary approval of significant treaties. But there are other issues which need to be addressed too, such as the time for scrutiny, what agreements are covered by scrutiny, and the specific approach to trade agreements. Let me just conclude this by then saying what practical improvements we recommend. Because we do recognise that whatever government's response, any change will actually take time. So we looked at what more can be done. 3 categories. Firstly, more time for scrutiny. Increasing the time period could be done by providing the texts early, for example, and there are other ways too, or by taking a more flexible attitude to the extension than we asked for them. And we also propose that government should accept a single extension request of up to 21 days if a reasoned request is made by Parliament, unless it gives reasons why that's not operationally sustainable. Secondly, better information. Scrutiny is improved where the committee can be informed of progress during negotiations. And we do receive private briefings from Department of Business and Trade negotiators. Why shouldn't this apply to other important treaties too? We've also recommended that explanatory memoranda are revised in line with the approach of the Australian and New Zealand governments, which include a national interest analysis, which explains clearly why government considers that that treaty is the right one to enter into and should be ratified. And a more reliable forecast of upcoming treaties will also help the committee plan its work. Third and finally, embedding commitments. To improve transparency and compliance across all Whitehall departments, the government should agree to bring together all its commitments or treaty scrutiny together into a single document. And I say all departments because different departments are responsible for treaties. We talk a lot to the Foreign Office, but they're not responsible for all of them, though they may be the filter. So we want all departments to know what the requirements are, and they should be embedded. So the government has said many times, if I can say this in conclusion at this point, government said many times it accepts the constitutional importance of treaty scrutiny, but it needs to give Parliament the tools to carry out the work.
Fantastic, thank you. There's plenty for us to talk about there. Let's go over, first of all, to Arabella.
Thank you very much, and thank you for the kind invitation to join this panel. So I've, as Lord Goldsmith said, I've recently given evidence to the International Agreements Committee, and I had the privilege of being involved in setting it up when I was working at the House of Commons. My current role at the Law Society is working across a broader range of public law issues, but and so I will, although I'm speaking here in my personal capacity, I'll make it clear if there's something that is the Law Society's view as well. And I'm particularly interested in the Scottish perspective, having grown up in Scotland, so I'm very glad that we have Clare on the panel here. I want to make 3 points if I have time. Maybe I'll come back to some of them later, but the first is about that I'm really delighted to see in general the importance of treaty scrutiny being recognised as a constitutional topic, and here we are, the Constitution Unit, talking about it, but you wouldn't have had this 10 years ago. A really important constitutional and political topic. As Lord Goldsmith has hinted at, you can make arguments for reform from a real variety of political standpoints, and that's my second point. And thirdly, a lot of the changes that are needed, around which there's a high level of consensus, can be done without legislation. So on treaty scrutiny as a constitutional topic, there really has been very little engagement with it, both amongst scholars and politicians for many, many years. When I first started looking into this sort of 10, 15 years ago, I found one book that touched on, well, 1.5 books that covered it for the UK, scarcely any academic articles, and almost nobody to talk to about it. So it's really wonderful having a kind of community now that is thinking and talking about and discussing and writing about these things. I think that was partly to do with a kind of a broad acceptance that treaties are largely an executive role. But it was also about this acceptance of the dualist principle that Lord Goldsmith has touched on as a very binary idea, separating international law from domestic law completely. And so there wasn't a lot of questioning of either of those two aspects. But what we've seen really is that over recent years, particularly, the degree of change, both domestically, regionally, and internationally, has really called this into question. I won't go into too much more about dualism now, but perhaps we can come back to that. There, politically, we've seen 7, I think, detailed inquiries in Parliament into treaty scrutiny since 2019, and more that touch on it. And one of them, the PAC Act, I always get this wrong, Public Administration and Constitutional Affairs Committee in the Commons, described treaty scrutiny as a core constitutional function of Parliament. All of them recommended reform, and it seems to be a real consensus around the idea that the current balance between Parliament and government, for there is a balance at the moment. It's certainly not exclusively a matter for the executive, but that balance has got stuck at the wrong place for a changing world. Why has the government not engaged with this as much as many of us would like? Well, often purely expediency. It's there's certainly you want more scrutiny of the treaties you don't like than for your own treaties. But the result of that is that the precedent remains where it is for the next government, and you find yourself unable to challenge treaties you don't like either. But it also, more interestingly, I think, ignores the reasons for why scrutiny is actually in the government's interest. So I'll try and touch on, if I have time. Do I have time, or am I running out, Lisa?
No, you've got a little more time. Go ahead.
Okay, I'll just touch on a few arguments for reform. The biggest one is that so many issues need regional or international agreement, and that's a very practical argument for needing more consensus and democratic involvement in treaties. Another practical one is that governments can use a consent requirement, a parliamentary consent requirement, tactically during negotiations. An argument against dualism as a kind of defining feature is that it should be protecting parliamentary sovereignty, and it's often actually wielded as in order to lock Parliament out of a role. We talk a bit about implementing legislation, as Lord Goldsmith mentioned, but also another dualism argument is that it doesn't currently completely shield domestic law. And that a greater role for Parliament is entirely compatible with dualism. One that I would have loved to explore more, but I have never been able to do this, is about the extent to which a greater role for Parliament could also mean that the courts are less likely to intervene in treaties. So I think I'll leave it there for now, but I've got plenty more I could say about what better accountability would look like later.
Fantastic. I certainly want to come back to some of those points later. But for now, let's hand over to Clare.
Thank you very much, and thank you to Arabella and Peter for setting out the bones of today's discussion. Very interesting to hear from both of you. I would just say at the top of this, I think my own experience in my third term in the Parliament is that certainly in opposition, people are a lot more in favour of scrutiny and transparency than they are once they get into government. So I really welcome this opportunity to contribute to this discussion. International relations, including the regulation of international trade, is of course reserved under Schedule 5 of the Scotland Act. So this means that on the outset it might seem that it's not of much interest, or that we're in the periphery of this. However, given the impact of international agreements and devolved competencies such as economy, food production of any kind, the environment, health, the input of the Scottish Parliament, the Senate and Northern Ireland Assembly cannot be overlooked. You might recall there was a bit of a stushy, as we say in Scotland, around the most recent EU-UK summit over the lack of engagement with the Scottish Government on fisheries policy, which of course is hugely important to Scotland and a devolved area of competency. The devolved legislators must be able to scrutinise the role of their own governments, and we are able to do that in influencing negotiation and international treaties. But we cannot compel the same level of scrutiny from Westminster and from the government in Westminster. So this means taking a view in relation to the extent of the influence and effectiveness of intergovernment relations overall. We have been carrying out, as a committee, an inquiry into intergovernmental activity, and we will cover some of the work in this area. But I want to focus on the UK-EU Trade and Cooperation Agreement. We've published 2 reports relevant to the forthcoming review of the TCA, first considering the challenges in the trade of goods, while the second concerns service providers, youth mobility, and touring artists. Much of the evidence we've heard from the first report was on the impact of non-tariff barriers on agri-foods. An overwhelming support from the business community in Scotland is for a veterinary agreement between the UK and EU. That agreement would involve either dynamic alignment and recognition of the equivalence of respected standards, and that would significantly lift the administrative burden on exporters of agri-foods to the EU post-Brexit. The Scottish Government told it would, quote, reduce the necessity for about 90% of cross-border checks, and it would make export and import much easier. So given the extent that that impacts on Scottish businesses and the Scottish economy, and it is in devolved areas in many instances, the devolved governments must be involved in the process of agreeing an SDS or agreement with the EU. And we have to improve our relations with the EU. A second report in the TCA highlighted the issues faced by service providers, lawyers, architects and vets, for example. It also considered the experience of young people looking to study, to work, to volunteer in another country. And in the cultural remit that we have in our committee, the impact on musicians and other artists wishing to tour in Europe was quite profound. We took evidence from legal experts, academics, economists, business organisations, young people, and those representing touring artists. We found that post-Brexit, everything was much more challenging. So for young people to access opportunities to work and study, with the processes and the costs of securing individual country visas became a barrier to those opportunities for young people. So our key recommendation at that time was that the UK and EU should agree to improve arrangements for business mobility, youth mobility, and mobility of touring artists, with further discussions around mutual recognition of agreements with youth mobility schemes to follow. Scottish musicians have also heard that touring in Europe continues to be an administrative nightmare, and we called on the UK government and EU to act on sectors of key concerns. So the second TCA report was published ahead of the EU-UK summit, with discussions of a reset of that relationships. And fisheries aside, the indications were of progress to come in respect of movement of agri-food products, as well as balanced youth experience scheme. And a high level of commitment to recognise the value of travel and culture and artistic exchanges, including activities of touring artists. We will be monitoring progress through the TCA review and delivery of the summit outcomes and what this means for Scottish business and service providers, young people and touring artists. And I think that the post-Brexit relationship with Europe highlights how the relationship between Westminster and the devolved parliaments has changed. The Internal Market Act has had a big change in the ability of devolved nations to have regulatory divergence from the UK. So in relation to those areas of devolved competence, it is absolutely vital that there's an opportunity for contribution at the negotiation stage through the government mechanisms for doing that, but also that as parliamentarians in devolved areas, in the areas of devolved competency, we should have an opportunity to scrutinise the UK government in its operation and its negotiation process, and also to ensure that we have an opportunity to input and influence what might happen going forward. Thank you. I'll leave it there.
Wonderful. Thank you very much, Claire. Really, really interesting stuff. This is just a quick reminder to those of you in the audience. Please do submit your questions through the Q&A function. We'll be coming to audience questions in 15 or so minutes. So now's the time. I just want to put a couple of questions to our panelists first. And one thing that I'm struck by is there's often debate about at which stage of an international agreement parliaments should be brought in. These are sort of multi-stage processes, the development of a negotiating mandate, the negotiations themselves, signature, ratification. Claire mentioned the TCA review, which is sort of a form of post-treaty scrutiny. Are there particular stages at which you think legislatures can add most value, or the accountability needs are most urgent? And does that perhaps shape how we might think about which types of reforms should be prioritised? Lord Goldsmith, I'll come to you first, if I may. You're on mute.
My apologies. We make no specific recommendation about the time at which we should become involved, except in the practical sense. The earlier we are involved, the more likely it is that we can gather the right material and evidence, and we can contribute to the debate about that particular treaty. And that's very, very important for all the reasons that are set out in the report. We need to know what experts think. Though we've got a wonderful, wonderful team working for us, they can't cover every subject. They can't know it all. So in order to make the decision-making better, which is ultimately what this is contributing to, we need to have the time to do that. On trade agreements, we're doing quite well with the government because they do come, they keep us informed. We have the negotiators come and tell us how they're getting on. In relation to other treaties, we can just really be bounced with them with very little pre-warning at all, and that's much more difficult. So it's a practical answer. The more time we have to gather the evidence and to scrutinise, the better it will be. Not that we waste our time doing it, because we've got plenty to do without having to make unnecessary inquiries.
That plenty to do might be something we come on to shortly, because I'm quite interested in some of these practical questions around how scrutiny can be facilitated. But Claire, thinking from the devolved perspective, you see international agreements go through this sort of life cycle. At what stages do you find consultation is most likely to happen, is least likely to happen effectively? What would you like to see here?
Well, the committees of the Scottish Parliament have a scrutinising function on the operation of the Scottish Government. We are set up to scrutinise bills and to look at legislation. So it's frustrating then to be in a position of everything happening at intergovernmental level with the civil servants. So realistically, a committee cannot get access to the thought process at the earliest stages and get that early involvement. It's usually after the fact or in the very late stages, or only if the government want to release any information to the committees themselves. So I think that lack of scrutiny and the lack of the ability to call a minister from Westminster to come and give evidence to a committee who may well have an area like food or drink or health committees, net zero, all of these things that will have a big impact on devolved issues. There is no constitutional mechanism at the moment to be able to do that at all.
And Arabella, can I bring you in on this question of how and when do we bring legislatures in?
There are lots of different ways I could answer that question. One is that at the moment, the formal role of Parliament comes only once the treaty is, it's only for some particular treaties, not for all, and it only happens at the end of after it's been signed. So the text is set by the time it comes to Parliament. If Parliament is to have any influence on the content of the agreement, it would need to be involved much earlier in the process. That sometimes is possible, sometimes it's not, much more for multilateral treaties than bilateral. So there are complexities around this. But the other aspect on the other side of it is that what is less talked about is the kind of future life of treaties when they're amended, if there's a proposal to pull out of them and so on. And in those situations, particularly withdrawal, as we know, there's very often not any kind of parliamentary process at all. So I think we need to look throughout the whole life of a treaty and what the appropriate role is for Parliament, which is one of the main challenges and opportunities here, the degree of flexibility that's needed in how much Parliament is involved.
You've preempted my next question, which was about withdrawal and whether we should be talking about more than simply entry into treaties when we have these conversations. So I'd love to get Lord Goldsmith and Clare's thoughts on that as well. Clare, can I come to you first?
Well, I think we've just been through, I suppose, the withdrawal from the biggest possible treaty that we had in terms of our EU membership. And I think the speed at which things happen is a challenge for business and for people to get their head around what might happen. I think if I look at it from a devolved context, the most challenging part for the devolved nations wasn't actually the withdrawal from the EU, what was replaced by the whole country. It was the implementation of the TCA agreement without legislative consent from either the Welsh or the Scottish parliaments, but it went ahead anyway. So that what we then saw there was one of the first times that the Sewell Convention wasn't followed, which, you know, is that one line in the Scottish Agreement and the Scotland Act and the Welsh Act is that the UK will not normally legislate in devolved areas. But of course, the Trade and Cooperation Agreement, I think the phrase our committee used, and I think PACAC used it as well, it's like driving a coach and horses through the whole devolved settlement. So if we look at that withdrawal in itself, it had a very dramatic impact on the devolved nations, and one that we're still struggling with, I would say, at the moment.
Lord Goldsmith, what are the International Agreements Committee's views on what role Parliament might have in scrutinising the ongoing life of international agreements and potentially withdrawal from them?
Well, I'm sorry to be difficult, but I want to take it actually in the other chronological direction. Because, and what we do look at, though we don't reach a firm conclusion in relation to it, is at what stage Parliament starts to become involved rather than what stage it ceases to be involved. And that picks up on a point which is raised by some people. It's been picked up in our conversation already, which is by the time a treaty is laid, it is set. And to some extent, it becomes a binary question. Now, we look at trade agreements. Generally, it's probably right that it's a good idea to have a trade agreement with countries. So even though it may not be a great trade agreement, you'll still say, yes, it should be ratified. And I think, therefore, there is a case. We don't reach a firm conclusion, but there is a case for saying that Parliament should be involved at an early stage. For example, and we say this is something that we had a lot of good evidence about in relation to trade agreements, at the time of setting the mandate for negotiation of a treaty, should Parliament be involved, as it happens in some countries, with the mandate for the negotiation at that stage. So that, I think, is an area before then. As to what happens, I come back to your question, as to whether we should be involved at the time of amendment or termination. We would like to be. It's not the priority as far as I'm concerned, but it makes sense that a committee which has already looked at an agreement should look at a suggestion that it should now be amended if it is in some important aspect, or that it should even be terminated when we've said it's a good thing. So I think there's a case for it, but this will have to be looked at as part of the overall reform proposal that we make. Yeah.
Okay, thank you. I just want to pick up on something that's been mentioned a couple of times, which is the issue of capacity. And I think it's an interesting theme in the committee's report that practical obstacles to scrutiny are really important and have to be thought about in addition to sort of broader conceptual questions about how things work. There are fantastic committee staffs operating in the Scottish Parliament, in the Lords, but they are small. Arabella, I think, was the only treaty specialist in the House of Commons for a while, and then one of quite a small group. What sort of capacity building should parliaments be thinking about if they are thinking about taking a more active role in treaty scrutiny? What would that need to look like? Lord Goldsmith, I'll come to you first because I know you've spoken about the pressures that your team are sometimes under in the chamber.
Well, it's actually connected with this question of time, because one of the ways that we manage to, as it were, increase the capacity of the excellent team that we have is by making sure that we get the input of experts, specialists and stakeholders who know the subject and therefore can already produce material that we can look at. Not that we take any of it sort of just swallow it whole, certainly not, but at least we can they can help to us identify the issues. So I think time is very important. That's a key part actually of extending the capacity to do it. Otherwise, we have to make decisions about what we can look at, and we do have to make sometimes quite hard decisions about whether we're going to spend time on something or we're going to move on to something else because there's a lot happening at the same time. So what resources do we need? More. We could do with more. I mean, I'm going to be very Oliver-like about it, Oliver Twist-like about it. We would like more.
And Arabella, the situation in the Commons is complicated, isn't it? Because there's no one committee which has broad responsibility for looking at international agreements in the same way as in the Lords, which perhaps leads you to slightly different ways of thinking about where capacity goes, how it works. What are your observations on that as a former Commons official, having seen this working or not working?
I think the main issue in the Commons is how to increase MPs' desire to be more engaged with this. So it does come up, and there are many very good examples where people want to be doing more of this kind of work, but it's also hard when if it's very hard to see what impact any scrutiny work that they do would have, and this comes back to the point of whether there should be an approval power later in the process. So the Foreign Affairs Committee, for example, did have a kind of overarching role on treaties, but it never used it, and it didn't have particular staff to look at treaties. I don't think it looked through them in anything like the same way that Lord Goldsmith's committee does. The one committee that did take an active role was disbanded when with the machinery of government changes, and the International Trade Department was disbanded. So I think if there were, given that we don't have a Commons treaty committee, one thing that could make a big difference is if, as has been proposed at various points, treaty scrutiny was a term of reference for all committees. There are staff in the Commons who can advise on these things, and it's just using them for that purpose. Another way of increasing capacity on an inquiry about a treaty would be to use the guesting procedures for Commons committees, so that a member of one committee can go and take part in another committee. And that's happened with devolved, I think with the Welsh Affairs Committee can have members from the Senedd coming to guest on its committee, and that's a really interesting example of how you can bring in expertise to do this kind of work.
Oh, you're on mute.
No, you've gone on mute.
Oh dear, it was my turn, I suppose. Clare, I know that you're also trying to tackle an extremely broad remit with relatively few staff, and I'd be interested to hear how you would think about capacity building in this area in the Scottish Parliament, and also how you potentially work with other committees on cross-cutting topics.
Yeah, it's a really important issue because the experts are few and far between, unfortunately. So as a committee of the Scottish Parliament, we can commission academics to be advisors to the committee. So if I think of Dr. Lisa Whitten from Queen's Belfast University as one of our advisors. And we also commissioned Lisa to do an EU tracker model for the Parliament that came from our committee, and that was to try and support and be able to scrutinise the Scottish Government's commitment to keep pace with Europe. So that's an example of where we had to build an infrastructure as a result of leaving the treaty that we didn't have in place before. So we do work closely with both the Senate committees and the Welsh committees as well. But I'm just aware that obviously post-Brexit, a lot of those people in those positions that were monitoring this kind of area probably dissipated into other areas of the civil service. But if the EU and UK treaty with Europe, if it makes a significant change in terms of the review of the TCA, where are the civil servants with that expertise? Where are the other people coming back in to recreate that infrastructure? So it's not easy to do, and I think we could always do with more resources. I don't think there's anyone in any kind of level of government that say that wouldn't be necessary, but it certainly has a big impact, and it can't be underestimated how important it is to have the right people in the right place.
Great, thank you. I think a thread that's run through this is that fundamentally improving the scrutiny of international agreements is about asking governments to give up some of their power and to give up some of their flexibility and their room for manoeuvre. And understandably, governments are reluctant sometimes to do this. They worry that parliamentarians will say, well, actually, we'll have all of the upsides of a trade agreement and none of the downsides. Thank you very much. What do you think is the positive case to government as to why improving the scrutiny of international agreements, as to why bringing in legislators more, allowing for greater levels of expert advice earlier in the process, is a valuable thing for them to do, and is something that they should positively welcome? Lord Goldsmith, I know this is something that your report touched on.
Yeah, it does. I mean, we identify really three things. We think it improves decision making. I mean, this is about complicated agreements in relation to important matters. I want to come back to that point because I think it's a thread running through this too, and we haven't perhaps made enough of it. It improves decision making. Secondly, it does actually give government a lever that it can use. And we know from experience it takes at the EU level, well, because they were able to say, no, negotiating party, the Parliament, European Parliament will not accept this, so I'm afraid you can't have that. And the same is true in the United States, we understand, because of Senate approval requirements. So it does actually provide the opportunity to push back on things that are taking place, because it's known that there needs to be that involvement. But the third point, and that's why I think it will help in that respect. The third point, I think, is just how important these topics are. And it was fine when international treaties were big agreements about geopolitical things, but not much else. But look what they're about now. They're about health, they're about environment, about human rights, they're about all sorts of things. And these are things that our parliamentarians are involved with otherwise. And why should their expertise and their thoughts and their views not be there in the mix as well when government comes to agree treaties with other nations which are actually going to set some of these standards?
Thank you. And Clare, you mentioned the potential for changing or improving the relationship with the devolved at times by approaching treaty scrutiny slightly differently. Could you expand on that a little?
Yes, and I think the stakeholders can have specific areas of interest that are not a generalist view from the UK in terms of agriculture in particular, the quality of the food that's produced in Wales and Scotland, and so anything that would open up imports that with the standards wouldn't meet the same standards here in terms of animal welfare, in terms of environmental impact, those kind of things. It has to be really understood what the impact might be completely, and that is about involving politicians who are working closely with these stakeholders almost on a daily basis in their committee roles. So I think getting the views of stakeholders is so important, and we have to be wary of unintended consequences. I think the fisheries one, where there was quite a different perspective from Scotland in terms of how good the fisheries deal might be and what might happen to the fishing rights in Scotland, shows that it sometimes there's a localised view that if you don't engage with the devolved nations, you might miss, and there might be unintended consequences that will damage the economy.
Okay, thank you. And Arabella, I know you've looked at this question comparatively to compare UK practice to what happens in quite a wide variety of other countries. Are there lessons that you think the UK should be drawing from its neighbours on how legislatures can improve their engagement with international agreements, how that relationship between legislature, government, and negotiation or treaty should work?
Absolutely. There's so many different models out there. I don't think there are two countries anywhere that do this in exactly the same way. So there are some really great examples in countries that operate on the sort of Westminster model. So we have in New Zealand there's an arrangement for debating a treaty itself in place of the first debate on any implementing legislation, for example. And we haven't really talked about that sort of timing, but that's an important one that comes up in the committee's report as well. There are dedicated treaty scrutiny committees in other parliaments, so for instance, in the long-standing one in Australia. And the sort of broader example of dualist countries that, just as we've mentioned before, do provide a much greater level of parliamentary involvement throughout the process, as in Norway, for example. There's a parliamentary committee that discusses major issues of foreign affairs, including many treaties, with the government before it takes any steps towards committing itself, and that's not seen as in any way incompatible with dualism. But I just wanted to make one other point about why it can help governments to have this greater involvement, and that is that treaties on the whole are quite long-lasting, and if you want the treaty that you're negotiating to really have good public support for a long period of time, bringing in a greater range of views through Parliament, a greater kind of understanding of the trade-offs that might be involved, could really help to do that. And public opinion tends to support it. And I know in your Democracy in the UK report, a couple of years ago, there was massive support for parliamentary scrutiny of significant new policies, and so I think it would be in the government's interest, certainly.
Great, thank you. With that, I think I better come to audience questions. I'm going to ask my colleague Tom to come back on screen. Tom, what do you have for us?
All right, thanks very much, Lisa. So I've got three questions to get us started on. So first, we've got a question from Stuart McIver, who asks, can you share treaty agreements that have been disastrous for the UK, which would have realistically been avoided with appropriate review? So I suppose that's one specific version of the question about whether changes in this area would actually make a practical difference in the real world for people. Then Matthew England from the Hansard Society asks, should all treaties require a parliamentary consent vote or just, quote, significant treaties? What should the criteria for significance be, and who should decide whether it's met? And then an anonymous attendee asks, how can the UK government ensure involvement of the devolved administrations at an early stage so that the context within the devolved nations' work is understood and appreciated? And they highlight an example of Northern Ireland, the border with the EU, and the application of the Windsor Framework.
Great, thank you very much, Tom. Claire, let me come to you first, if I may, because I know you have to leave us a little early today.
Yeah, thank you. I have to go for the vote. Yeah, very interesting questions. In terms of the disasters, I think I'll leave that to the other members who have been working in the area of treaties for a lot longer. I can mainly speak to the context of the last 4 years and post-Brexit, the time that I've been in the Constitution Committee, and Northern Ireland's been a really interesting example for us. As I said, they're still having to track EU law, they're still having to do all that work that was done pre-Brexit, but as I said, as a Parliament, we had to commission work from someone to give us an EU tracker to see that, because we were no longer in receipt of that information from the EU and from Westminster. It used to come through in massive amount of EU regulations on a monthly basis. So I guess that, you know, capacity-wise, it leaves you a bit in the dark when things don't go the way you would have liked them to, and you can be left in a sort of vacuum of information at any time. I think that in terms of the devolved nations, I think in general, we have worked very well with our House of Lords counterparts and through the Interparliamentary Forum, which came from Brexit, which is a very good way of working together, and that brings the devolved nations together to raise some of these issues, and we do get a chance to speak to a government minister then. but the opportunities for the devolved nations in particular are much less than I would say the committees in Westminster, which makes us feel even further from the scrutiny, transparency and policy making of the whole process.
Great, thank you. Lord Goldsmith, I think our remaining questions were, should all treaties need a vote? And if it's only the most significant ones, what is significance, who decides? And are there either disasters or missteps that better scrutiny might have helped us avoid?
You never really know. But I will give one example, though, which was that we scrutinised the Rwanda Treaty, this last government. Interestingly, I mean, we looked at it. We didn't say it was fundamentally a bad idea, but we picked up the safeguards which the government itself said were needed in order to make the Rwanda treaty arrangements work, and say that there should not be ratification until those had been put in place. And that was actually a report because we're a cross-party committee, was agreed to by all members of the committee, including the Conservative members. And it's the one occasion that we voted in the House as a whole on a treaty, and the House as a whole voted that government should not ratify that treaty. So I think it's an example of a political thing which came before Parliament in the context of a treaty, and Parliament, the House of Lords, it was only because we're the only ones that looked at it, said no. I mean, obviously we know what then happened, because then there was a general election and it sort of didn't go ahead. But still, I think it's quite a good example of what can happen, and indeed can happen on a cross-party basis. On the next question, I mean, if we only look at significant treaties, how do you decide? Very important question, and that's something which would have to be decided in the context of the legislative reform. We already do screen certain treaties out on the basis of criteria which we've set up. I mean, it's not quite the same, because it's those that we think, for reasons that they're similar to other treaties we've approved already or something like that. But you can set down criteria to do it. And I would hope, if we get to that stage, that you'd actually have a cross-party committee that would be making the decision as to which treaties were significant and required approval and which didn't. But I think that's, it's a very important question, and it would have to be looked at. But I think there are practical answers as to how one would achieve it.
Mm-hmm. Arabella, can I bring you in on these questions?
Thank you. So on that last point of significant, how do you decide significance? Again, many different countries do this in different ways. So there are lots of examples to look at. I think one of the crucial things is who decides what's significant, and a kind of a quite acceptable model would be, for instance, for the government to decide initially whether what level of significance a treaty has, but to give Parliament the power to challenge that. And in a slightly different context, that's what happens in Australia at the moment, for example. On the question of now where were we? Sorry, can you remind me what the second question that we were?
Yes, so there was, are there missteps that might have been avoided? And yes. How might the devolved nations be better brought in at an earlier stage? So I think while voting against a whole treaty is obviously an important part of the consideration here, as with most parliamentary scrutiny, it's not so much the extremes that matter, it's the everyday influence and small changes along the way. So I would look to those as just as an equally important part of improving parliamentary scrutiny. On the bringing more involvement with devolved legislatures, I'm so delighted to have this conversation, because so often in the treaty context, it's the conversation is about how the devolved executives can be more involved, and of course that's has its own challenges, but the challenges for the devolved legislatures goes even further. I've sometimes talked about scrutiny challenges squared for when treaties are implemented not by primary legislation but by secondary legislation, so you've got two levels of challenge, but with the devolved legislatures you could even think about it being scrutiny challenges cubed. So that's not giving you any answers, but just kind of illustrating the scale of the question, of the challenge. Also important. We have just 5 minutes left. Tom, can you give us
Can
a
I,
couple of...
before we do, could I just make a comment on devolved?
Please do. Yeah.
Because I didn't touch on that question. We think that's very important. And indeed, we're engaged at the moment in a process of going round the devolved nations, talking to the assemblies. I was in Belfast last week. Colleagues, I couldn't actually make it, were in Wales with the Senate, and we're negotiating. Clare is gone, but I think she's one of the negotiators, a date for us to come to Edinburgh to do the same thing, so we can talk about scrutiny as a whole, but also make sure we have in place, as I've now put in place for Wales and for Belfast, arrangements to make sure that the scrutiny can include the assemblies, at least the legislatures.
Fantastic. Tom, do you have one or two final questions for us?
I do. Thanks, Lisa. We've had lots of great questions, but I'll just pick out two as time is short. So the first is from Mario Mendez, who asks, is there a risk that now we have the IAC, the elected house is actually less likely to get engaged with treaties? The Commons can in effect leave this issue to the IAC and then not meaningfully engage. And they highlight a difference to New Zealand, where there's a unicameral elected house that has a committee, or in Australia, where there's a joint committee that therefore has members of the elected house. And another question from Matthew England, who asks, in light of its use to ratify the UK-France migration treaty last month, what do panelists think about the very broad Crag Act power to ratify a treaty in, quote, exceptional cases without going through the normal procedures?
Mm-hmm. Okay, and I'd add that we've also had the disapplication of CRAG through a line in primary legislation before for some of the Brexit legislation. So there are various ways in which it has been set aside. Arabella, I'll come to you first.
Thank you. The exceptional cases, I'll start with that. I think what we don't have at the moment is any real understanding of the criteria, the government's criteria for what make up exceptional cases. And that would be really essential to understand and to have much more clarity about. On whether the Commons is leaving it all to the International Agreements Committee, that's not necessarily a bad thing. They do a very good job, and I understand that there's a lot more communication now between the Commons and the Lords than there has been at some points in the past on treaty scrutiny. So there could be a model of the Commons benefiting even more directly from the Lords' scrutiny and working closely with them to work out where a Commons Select Committee could pick up problems that the Lords have identified, for example. But it's not an ideal situation, and given that the Commons is the body that has the power to actually, well, not to stop treaties, but it has a stronger power on treaties than the Lords. It doesn't feel constitutionally appropriate for it to have no clear means of exercising that power.
Lord
Goldsmith, you have the final word.
Well, thank you very much. There are two things I want to say. One, I just agree with what Arabella said. It's very important. I'm talking to colleagues in the Commons about this very issue, and you may have noticed that in the most recent Foreign Affairs Committee evidence session that they took, Emily Thornberry, the chair of that committee, did ask a number of quite searching questions of government about scrutiny. So it's not as if this is ignored in the Commons at all. We can continue to work with them. The second point I want to make, the final point I want to make, is just to remember that Parliament, both houses, frequently spend a huge amount of time looking line by line at primary legislation, scrutinising it. Government has to put up with that, has to accept it. They will have their supporters and their detractors, but they have to do that because that's what makes legislation better, that scrutiny. The surprising thing today is that treaties are dealing frequently with every bit as important topics as are being dealt with in primary legislation, yet that line-by-line scrutiny is not taking place. That's what we think needs to change.
Wonderful, thank you. Sadly, we are out of time. So let me say very many thanks again to our speakers, to Lord Goldsmith, to Arabella Lang, and in her absence to Clare Adamson. And thank you to Tom for fielding the questions and to all of you for joining us. You'll soon be able to find a video of this session on the unit's website and on our YouTube channel, and the audio version will be released as a podcast. So do point others toward it. And keep an eye on our website for our next seminar. But for now, that's it from us. Goodbye. We hope to see you again soon.